morning, and thank you all for joining us today. My name is Joanne Carreri, and I'm president of Saginaw Future. Economic development organizations and chambers of commerce from throughout the Great Lakes Bay region have been inundated with questions from businesses and local governments about the impact of the Michigan Medical Marijuana Facilities Act. It's because of those many questions that our sponsors have come together to provide this informational panel. I'd like to take a moment and thank our sponsors who are listed on the screen. We have a little applause. Thanks so much. We've asked a group of leaders and experts to join us today to discuss the Act, present the facts, and answer questions that you might have. Please know that the sponsors of this panel are not making any value judgments about the Act, nor the local community's decision on how involved they might become. We are merely providing information to help educate the community on this Act. Because of our time constraints, we're asking that all questions be submitted in writing. So if you have a question, you should have an index card. Just hold it up during the session, and one of our runners will come and get those and bring them up here to us. We'll do everything we can to answer as many questions as we can, and thank you so much for honoring this process. In the order that they will present this morning, we have Colleen Curtis, Manager, Legal Section, Bureau of Medical Marijuana, Michigan Department of Licensing and Regulatory Affairs. Jennifer Richterink, Legislative Associate, Michigan Municipal League. Jeff Mays, Director of Economic Development, Consumers Energy. Clyde Robinson, City Attorney, City of Kalamazoo. And Bruce McCauley, Assistant Special Agent in Charge 2, Detroit Division Office, Drug Enforcement Administration. Each will cover areas of the Act, and again, we will hold all questions until the end of the 5 presentations. Thank you very much. Our first presenter is Colleen Curtis, Michigan Department of Licensing and Regulatory Affairs.
Good morning. I'm Colleen Curtis. I'm with the Department of Licensing and Regulatory Affairs, Bureau of Medical Marijuana, and thank you for having me today, for inviting me. This is a topic that is keeping us very busy, the Bureau of Medical Marijuana. So how do we get to this point? The LARA, which is the acronym for the department, started working to implement the bills that were passed by the legislature. There was 3 bills that were passed, and on December 15th, the statute required the department to start taking license applications. So we've been very busy getting the program ready. We've also been working on research, trying to meet with the industry, bring ourselves up to speed on this very important area. The statute assigned the department, which is one of the largest regulatory bodies in the state of Michigan. We license nearly 1.5 million people, so we know licensing. And we're coming at this from a regulatory aspect, hoping that the industry and the future businesses, that's our focus. The Act, the Medical Marijuana Facilities Licensing Act, gave the department 1 year to implement this. And Director Edgerton created the Bureau of Medical Marijuana Regulation April 2017. It was an effort to consolidate the state's efforts in this industry area. And Andrew Brisboe is the director of the Bureau. Like it was mentioned, I'm the manager of the legal division of the Bureau. And my focus has been working on emergency administrative rules. I am now working on permanent rules, and I will discuss this further in the presentation. I'm also tasked with the public bodies, the Medical Marijuana Facility Licensing Board, and the advisory panel, which can make recommendations on the rules. I also have other duties, but I won't go into those today. The statute, just to give an overview, I think most of you here are probably familiar with it. The statute created 5 licensing categories: the growers, processors, provisioning center, safety compliance facilities, and the secure transporters. There was also an act that created the marijuana tracking system that I mentioned earlier, the CDCL system. Also, there was amendments to the current initiated law program to allow for marijuana infused products. So what's been happening? The licensing system has been created, the board was appointed, and they have began holding public hearings. The legal division held some work groups in September to get some feedback from the industry, patients, caregivers, attorneys, scientists, geared towards the permanent rules that we're working on now. The department has also held education sessions at various locations around the state with a focus on the license application and the CDCL tracking system. December 4th, the emergency rules were filed with the governor. Like I said, I'll talk about those in a minute. And then, as I mentioned, the department just started taking licenses. We have not issued any licenses yet. We're looking like 120 days out, so maybe April, we're thinking that might be the time frame that the licenses will be issued. Some of them. I mean, there's some in the pipeline right now, so it will depend on who passes the background checks, who has a marijuana facility plan, and ultimately the board's approval of the license. The board has met 5 times. In 2017, there's 7 meetings slated for 2018. The next board meeting is January 19th at the Kellogg Center. So if any of you are interested in attending, it also is streamed. You can also stream it. You can watch it on your computer. The Marijuana Advisory Panel, part of that has been appointed by the governor. There's a few categories that are waiting, and that's because the statute requires a licensed grower, for instance, and no one's licensed yet. That panel can make recommendations to the board and the department on administrative rules. There is a bill that's pending in the Senate right now that has some legislative fixes to the act, and that was something the department made a few recommendations. For instance, Section 205 of the act deals with the municipalities and opting in, opting out. We suggested it streamlined so we didn't receive paperwork, and there wasn't a backlog. We would rather have the municipalities tell us that they passed the ordinance rather than getting like all the ordinance copies. So it's just some technical type of fixes as far as that section goes. Also, there's the secure transporters. The bill would allow safety compliance facilities to collect samples without the use of the secure transporter. Is a clarification. There are a few other things in there, but I just wanted to mention that that is something that is pending. Laura has issued some advisory bulletins. This is our way to help the industry understand what direction we're going to take and to provide information. There may be some more of those coming out as we go through the process and learn what needs to be clarified or what might be useful to the industry. We issued a technical bulletin on the testing that to clarify something in the emergency rules already, and there might be more of those type of bulletins coming up. Okay, now to the rules and licensing. And the emergency rules are a skinny operational framework. They were to help us get the program going. The permanent rules are something we're also working on, and they take longer. They go through the Administrative Procedures Act procedures, and that requires a public hearing, public comment, testimony. So everyone that's interested can come and give us feedback on rules. The emergency rules might be like a framework, and you can give us your suggestions, what you think might work better. You know, we're willing to listen to any input on those. An overview on some of the emergency rules and the application highlights that you might be interested in. As I mentioned before, the emergency rules were drafted because the statute gave the authority to promulgate those because they may be necessary to implement and administer the act. And we were running on that 1 year to implement all of these procedures. We wanted to have something in place to get the industry going. One of the rules that might be of interest is background checks. The state will be thoroughly vetting applicants and supplemental applicants. Another rule pertains to inspections. There will be requirements that there's building inspections. If a local jurisdiction has that building inspection authority, they will use that. If not, I think it reverts to the state building code in certain instances. The state fire marshal is tasked with inspecting the marijuana facilities for fire safety. Let's see. Another rule you might be interested in is there are reasons for denying a license, and one of them is your marijuana facility plan. You submit that to the department, and the department reviews it, looks at the your security plan, the measures, the type of building you have, where it's located. You're required to submit the affirmation that the municipality has passed the ordinance. And if that isn't in part of your application, then your license will be denied. So the locals have to basically approve this before a license can be issued through their ordinance. Co-location, operation in the same location. I'll take the opportunity to clarify a rule that we've got some questions on. Basically, there's several parts to one rule. Sub-rule 2 of Rule 24. Please read it all together. Basically, the intent is that if you, for instance, are a grower and you want to have the same location with a processor, if the municipality has an ordinance that says we only allow growers and secure transporters, for instance, then you can't go beyond the municipality. You can't co-locate the two types of facilities that they didn't allow. So that was the intent of that rule. The inspections, I think I mentioned that a little bit. There's a pre-inspection and then a final inspection. And after that, the fire marshal, the department, its agents, inspectors, and the state police can then go inspect your marijuana facility. Advertising, that was just a baseline in the emergency rules. The locals can add other restrictions. I know some have asked if they can add odor restrictions, and that's up to the local body if they want to do that kind of thing. For the applications, attestation E requires the clerk or their designee to authorize temporary operations. And that requires a signature. You submit it to the department. We're not issuing temporary licenses. We're saying that if it's authorized by the locals, you can operate, and it won't be an impediment to your license. So there is no temporary or conditional license. The Section 205 attestation form in the application requires the clerk or their designee to affirm that the municipality has passed the ordinance. I think that's about it. I don't want to take up too much time. I know you all have probably questions. I have cards available with our website. The main line to call the Bureau if you have questions, we have analysts answering the phones, is 517-284-8599. Thank you very much.
Thanks so much, Colleen. And next we have Jennifer Riedrink, Legislative Associate for the Michigan Municipal League.
Good morning. You guys are a quiet bunch. It's hard to see you out there, but I have a couple of questions. How many of you are from communities who have adopted an opt-in ordinance in some form or fashion? Okay. And how many of you are from communities who have opted out entirely? Okay. And how many of you are in communities that are still deciding what to do? Okay. So if you're looking around, it's a very mixed bag of where we're at. And I'd say that is a consensus around the state. As Joanne said, I'm Jennifer Riedrink. I am a lobbyist with the Michigan Municipal League, overseeing any of our economic development, land use, zoning, planning, and municipal service issues. So I worked on medical marijuana legislation when I came to the league about 2 years ago. And one thing the league has done, or is continuing to do, is we are looking to help educate our members, answer questions, not persuade a community to go one way or the other. This is a very local issue where locally you need to have the discussion, what makes most sense for your community. And there's a lot of things to consider with looking to opt in, opt out, or wait and play the wait and see what's next. Up here on the screen, you'll see we have at the league, working with our municipal attorneys group and our legal defense fund, put together a resource for, of course it's already out of date because the emergency rules had not been put out yet. It came out a couple weeks after, but it's still very relevant, still kind of walks you through a process of questions to ask. I'm very happy that Clyde is here. I am not an attorney, so anything that I say or answer should not be taken as legal advice or a legal opinion in any way, shape, or form. But there's a lot to consider, and communities across the state, we have some who have opted in and have just opted in. They're not limiting license types or number of licenses. We have others who have very carefully looked at what makes the most sense in their community, where it goes. But there's a lot to consider with the zoning. Is it going to be a permitted use, a special land use? Are you going to use an overlay district? Security, signage, inspections. And then what if there's violations? What if you do opt in and someone is violating your ordinance? How are you going to enforce it and handle that process as well? Working on the legislation, I would like to compliment the state with Director Edgerton and Colleen and the team. They have been great to work with. This is a very complicated subject, and there's still unknowns as we get into it. But when those emergency rules came out, I would say, from the league's perspective, we were happy to see there weren't really any surprises in there. There's a lot of backing up what a local municipality has decided through their ordinances, and those rules back up locally. Specifically, we're talking of the co-location, the stacking of the licenses, things like that. It says, unless otherwise, with the local municipality. So looking at what you've decided locally, that is one thing that the league has worked tirelessly for through the legislation. If any of you are following the different bills out there, there's over 20 that were introduced in 2017. Some of them are not, they're not going to go anywhere because they were in reaction to things. I think the rules have clarified now and moving forward. But one bill that Colleen mentioned, House Bill 5144, Representative Kesto, that is a bill that has the technical fixes. It's specifically with local municipalities looking at Section 205, clarifies what is your responsibility when a license has been applied for at the state. It has taken a lot of the actual paperwork you'd have to send. There's a form where your clerk or his or her designee attests that you have opted in, have the ordinance for that license type, and any other applicable regulations that go along with that. There's been a lot of questions that the league has gotten about, and we've actually already seen some communities who maybe opted in very quickly, either had a change in their governing body during the last election, and or as they've gotten into this further have decided, okay, maybe this isn't the best for us right now, and have rescinded or repealed the ordinance that they passed. And then we have others who have started or holding off again. So this is a very locally driven decision. A lot of different information out there. Always be checking with your municipal attorney or legal counsel on any of your questions. I just want to mention, because I am here more to answer your questions than talk a lot, but the league has done a lot of education around this. We did some You Need to Know events around the state where we had a municipal attorney come in and talk about the act, as well as a panel of industry folks to help educate in this that might be out there. We will be continuing to do that in this new year, as well as our Capital Conference that's coming up in March. We're going to be having a 3-hour pre-conference medical marijuana workshop, as well as an update from the department on where we're at in mid-March as well. So with that, I will sit down and I look forward to your questions. Thank you.
Thanks so much, Jennifer. Next we have Jeff Mays, Director of Economic Development from Consumers Energy.
Good morning. Very much appreciate being here on behalf of Consumers Energy. Early in my career, I had an opportunity to serve as a township supervisor and certainly understand the commitment in this room to the residents and the businesses in your community and the important work you do each and every day. On behalf of the Consumers Energy, though, we're very fortunate to serve gas and electricity to most of the communities represented here today. But where we don't serve gas or electricity, I will say most of my comments will be really applicable to any utility provider. That being said, as we talk about this emerging industry, many of the comments that I have today are focused at the growing facilities that are certainly energy intensive. But if you take one message from me today, whether it's this industry, a dispensary, a growing facility, or any business that's looking to grow or site in your community, always engage your utility or energy providers early in that process. And to find success for that business, that prospect for your community, that's always a good practice, and whether it's with Consumers Energy or energy provider. So we've had a chance at Consumers Energy over the last year to really try to get our arms around this emerging industry. And it's very dynamic in nature. About a year ago, I had a chance to spend some time, and since then, talk to peer utilities in Oregon and Colorado and other states that this industry is growing and to get feedback. And so as we look at this industry, a few things they pointed out early on is helping our team of folks working on this really try to get out front of this industry. One, what they shared with us, and we're seeing in Michigan, is a clustering in rural areas in some instances. We'll go through some challenges in clustering in rural areas, but number one on the list is limited energy capacity, right? More urban environments isn't in place there today, requiring the utility, whether it's us or other utilities, to really consider how are we going to serve this growing industry and do it quickly. We also found, and again, other states have told us this, other utility providers, when they go into urban environments or reuse former factory or big box building, or quite frankly, any infrastructure or buildings that are currently there, it's important to engage the utility too, that even though it was a energy-intensive manufacturing facility, we're finding that the energy needs, particularly of growing facilities of our nature, that as they move in these facilities, and actually other utilities in other states shared this, they move in these facilities, hook up their equipment, and start using energy only to find that the energy system there, their own building infrastructure is inadequate. They can actually damage their own infrastructure and cause issues to the grid. So again, what we ask is no matter what the element of this industry is looking to site in your community, encourage them to engage us early and feel comfortable to reach out to your utility provider, to Consumers Energy, to assist with making sure that their needs can be served. Engineering considerations is that in many instances, the energy needs, particularly in those rural areas, are going to require the utility provider to do upgrades, whether again that's Consumers Energy or another utility company. And so making us aware of that is important early on. In some instances, because this industry wants to be moving very quickly, we have growers that are looking at wanting to start construction fairly soon and be operational fairly quickly here in 2018. In many instances in these rural communities, we have limited low voltage capacity. What do I mean by low voltage capacity? It's the type of service that serves our home, most of your units of government, corner grocery store. It's our distribution system. And so we actually have very limited capacity. In some instances, not all. Every community is different. And so what's going to happen is the prospect that can come and provide their energy needs and are willing to sign into an agreement for that capacity will get it first. Our goal as a utility is to never pick winners and losers amongst our customers, but the reality of our system, those businesses that show up first, depending on the constraints or opportunity in the area, are going to have short-term low voltage service available to them, and then we're going to have to go about the process of expanding capacity in the area. In some instances around the state, we're having to bring high voltage service. And again, my engineers here, they always kind of get nervous when I start talking about this, but it's more that transmission grade power, right? The distribution system is more local in some primary roads. When we start talking about high voltage, we talk about some of our busiest primary roads or the state's interstate system. And as you know, building those type of roads take a lot longer than building, maybe a subdivision road or a smaller business district's road. And so those things take time. As a practice, utilities do not overbuild their system. Needed that infrastructure. So when you build high voltage, it's a little different than, again, that distribution power. It takes time. Okay? Why does it take time? When these customers want to be up and running. One, we have to build, in many instances, not all, new substations, and we have to build out the line. Unlike the low voltage or that distribution system, when you do a transformer or build our infrastructure for the high voltage side of the business, unfortunately you can't run to the Home Depot to buy this stuff. All these things are specifically engineered. And so we need time to go build out that infrastructure, engineer it, order it. In some instances, we need to go get right-of-way. And sometimes we have to get many miles of new right-of-way in which to build power lines and to build new substations. That takes time and often comes with a cost that that we need to work through. In addition to that, again, when we engage property owners, we're going to look to many of the local communities to assist us. Often when a utility, whether it's Consumers or another utility provider, shows up and says, hey, we would like to buy property rights to put our infrastructure there, often, folks, it's a very personal decision. It's a financial decision to allow us to use their property, and so that can take time. For us, managing risk is very, very important. So the larger the project, and some of these, potentially are in the millions of dollars range, no different than the state, no different than a bank that's lending money. We are going to want to review in some instances the financial viability of that particular business. And we also know that many of these businesses that we're working with today don't have a license yet, right? And so many of them may not be willing to make a commitment to the utility until they have that license, but at the same time that impacts, we know, a project going forward. Things to think about, as I said before, if you take away anything from my comments today, always engage your energy provider early in the process. Time is an asset to our engineers and our folks to work through sometimes very complex things we need to do to serve our customers. The larger the project, we may need to review that business's viability, and that may impact how we go about serving the project. We have kind of a chicken and the egg situation, particularly in those rural areas. It's very easy for an energy provider to look at a single project at a single site and come up with engineering solutions. Knowing all the potential projects in a particular area are important, and which ones are viable to move forward, because that may impact what we build. And what we don't want to be is in a situation where we're beginning to build to serve customers and the system we're building is already inadequate based on the customers that are approaching us. So that feedback's also important. We're not going to really proceed at building anything until we understand the energy needs. Applicable contracts are in place, right? We don't know, we're no different than any other customer, which business is viable until we can enter into some type of agreement to understand their needs, and both the customer and we as the utility all understand our roles in that process. In some instances, we may need the customer to contribute to that project or have a deposit, but I can say we as a utility, no different than other utilities, have construction incentives in place in which to assist with the building of that infrastructure. But again, it's going to be on a customer or project basis. Natural gas. Natural gas is important. It's important for us to know what their needs are, particularly if they're looking at some type of self-generation, right? Whether it's backup generation in the event of an outage or whatever their particular needs are. It's also important to know if they're looking at incorporating any renewables into their business, because that impacts how it connects into our system or energy provider would want to know that information. We as a utility, no different than other utilities in Michigan, have some very strong energy efficiency programs, and which have rebates and assistance we can provide to assist that grower to optimize their business. And so engaging us early allows us to engage our energy efficiency professionals and look at ways, like with all of our customers, to make sure they can build the most efficient operation possible. So our goal as a utility, again, we're working really hard to get our arms around this industry. We want to support our communities. We want to certainly set expectations. We are trying to do some things early where we're aware of projects, where we're trying to scope past, look at routes. And as a result, we are engaging those communities that we're aware that are involved with this industry, particularly for those growing energy-intensive operations, to maybe partner, work together so that we can deal with those right-of-way concerns and put in our infrastructure, and to make sure we're meeting the needs of the local community as well. As a company, I say weekly, but we're virtually having, because of the number of projects that are coming our way, virtually daily meetings trying to put together strategies at various corners of the state, to make sure we meet the needs of these customers that, again, their timelines are very aggressive for their energy needs. We want this, as all of our customers, to be successful, and we look forward to answering questions later in the program. Thank you.
Thank you, Jeff. And next we have Clyde Robinson, City Attorney, City of Kalamazoo.
Good morning. Up to this point, and with all respect to the previous speakers, it's been kind of dry, kind of boring. Hopefully I don't want to concern a little bit. I mean, it's a serious issue. I do have a PowerPoint that's going to guide my remarks. I've also jotted down a few things let me get those off my chest first, then we'll run through the PowerPoint. House Bill 5144, that's already been referenced. That is actually been passed by the House, has gone to the Senate. The Senate has approved a substitute, I think it's Bill S-2, that has basically taken the House bill and reworked it. It is, I think, cleared committee, but it has not been voted on by the full Senate. So once that occurs, then there will have to obviously be some reconciliation between the differences between the two bills. Again, Jennifer is closer to this process than I am, and I would expect that to come into place and be adopted hopefully shortly after when the legislature comes back into session. I don't know if they've come back yet after the holiday break or not, but I expect them to act on that. Interestingly enough, it's already been mentioned, section, I think it's 205, where you have the ability for locals to opt in, opt out of what you can and can't do. That is critical, and I want to make a reference to it, as I also have it in my PowerPoint. Currently, if you're looking to opt in, what can you do? What's the canvas look like in terms of your regulatory powers? And before I get there, I'm kind of curious. I want to know who I'm speaking to. And I'll tell you, I'm neutral on this. But how many of you are local elected or officials or employees of municipalities? Oh, good. How many of you are from that represent the medical marijuana industry? Either you're a lobbyist or a lawyer or... Oh, good. That's a friendly house. The Section 205, as it currently is written, says here's what a municipality cannot do. Basically, very broad. But you may not impose regulations regulating the purity or pricing of marijuana. Okay, so purity, pricing, that's going to be left to the state. Or impose regulations or interfere or conflict with statutory regulations for licensing marijuana. Now, that's the wording currently, statutory regulations. Statutory is the statute. There's not a lot of regulations in the statute. So the curative language is that you're conflicting with this act or rules that will be issued for municipalities, which means Lara is going to start occupying that field that they haven't, up to this point, been able to do. And that's kind of interesting because the emergency rules that are in place do, in some ways, handcuff what municipalities may do. So you have to be aware that if this change goes forward, the canvas that you're able to write upon has gotten a little smaller. To say that, I'm not saying that the Lara rules are onerous or difficult, but they are different, and they do take away some local options. Where they have done it, and Ms. Curtis already indicated that they're running stacking. There's a clear recognition of the local authority, but that clear recognition is not pervasive throughout the rules, at least as they stand now, when the permanent rules are adopted, whether that will continue to be the case. So it's something to watch and be considered. And in that regard, the rules do talk about a certain fire code. If any of you are familiar with fire codes, nationally promulgated fire codes, there's more than one version. Obviously, the state has adopted one, but you as a municipality may adopt a different one, and then now they're going to have conflict. So if the rules say, hey, we're going to follow this particular fire code, and I don't have the cites, but it's referenced in the emergency rules. There's a specific fire code that they are going to use. If you've adopted one of the other ones, I think there's at least two more maybe that you can opt in as a national promulgated code. Now you're going to be at odds because they don't necessarily track neatly. So again, something to be aware of. So with that, and one other thing, Lara is familiar with, and some of the, again, this more than just your zoning and general police power. You've got the, and I reference your fire code, your building code, mechanical codes. Lara is already ahead of this. I don't know when they gave this presentation. It's available online. I found it. It's called Medical Marijuana Regulation. Their PowerPoint's available. It's BCC course hashtag CP-17-0076. And it's just a PowerPoint presentation, but it's very helpful in terms of, okay, how are we going to classify various types of facilities? Are they like a Class M? Or I'm not an expert in building inspections, but for those of you who have some passing knowledge or know that field, very helpful in terms of, this is what Lara is giving out to people. So again, kudos to Lara for getting ahead of the thing. The other thing, if you are a local official, this month's review magazine put out by the Michigan Municipal League is the February issue for 2018. I have an article in here near the front. It's entitled, and I had a longer title, and the league kind of edited it. It was to opt in or not. That is the question for your hamlet. Okay, I see I'm speaking to everyone else. I'm on a university campus. Anyway, but they cut out the last phrase. So it's to opt in or not. That is the question, and I wrote it with the help of a couple of other municipal attorneys. And again, it's going to reflect some of my remarks today. If you're a municipal official and you get the magazine. So with that, I will try to go through quickly. PowerPoint. Here we go. It's already been mentioned, and I'm going to skim through this really quick because I'm assuming you have some passing knowledge, and some of the other speakers that have preceded me have already addressed it. 5 types of operations that you can. If you opt in, you don't have to permit all of them. You can only, if you wish, you can say, hey, we're only going to limit this to dispensary provisioning centers or only testing centers, whatever you wish to do. You don't have to opt into everything. The question I have is if you opt into growers, can you say we're only going to opt into the smaller quantity growers? I think you probably can. I don't think you're required to say we're going to have big operations, and that's another important thing. But Laura has said stacking of the big operations is permissible. So if you've got that 1,500 grow operation, they can get multiple licenses. So it can become 15, 3,000, 4,500, 6,000 plants, operations. So you may wish to say, yeah, we're going to opt into growers, but we're only going to permit Class A or Class B grow operations in our community. So something to think about. This is the state screening process. This is just kind of a short version of what it takes to get a license from the state. It's not as complete. Again, one of the things I'm going to tell you is consult your municipal attorney, consult the statute. As I said, the statute's going to be probably amended, and also look at the emergency rules that have been issued. But it's clear that one of the things that has to be important, and when I get to talk about ordinances, I would stress putting in the fact that it is a privilege. It's not a right, and it's revocable. So there is no argument that can be made, say, hey, I got this right, you can't take it away, I'm entitled to due process. Nonsense. We put you on notice, you are operating and you're selling a product that currently is unlawful, both under Michigan Public Health Code and federal law. I mean, even if the use of marijuana changes in November of this year, at this point, it's still unlawful. There's a group of people who are permitted to use it for medical purposes, which is about 2% of the population in Michigan, who are either a registered caregiver or a registered patient. So for the 98% of the rest of the state, it's unlawful to possess and use. I wanted to talk about, and you're going to hear, this is going to be a windfall for you. You're going to get all this money. I don't think so. And here's why. Various things that I've done some research, and on the low end, and here's how this works. There's going to be an excise tax of 3% at the provisioning center level, at the retail end of this. When the patient or the caregiver comes in and purchases the product, they will be charged a 3% excise tax. It's a little unclear to me whether or not the general 6% sales tax is going to be on top of that. I'd rather think that it is. I can't believe the state's going to avoid that because it's not a pharmaceutical in which there's no tax on. It's not a food product in which there's no tax on. It is an unlawful substance. So I'm guessing that the state's going to tax it at 6% plus an additional 3%. But that's not clear to me, at least in the law. So I've heard that when in 1 year there's going to be on the low end $650 million up to $1 billion worth of sales, in which that 3% is going to be applied to. So we do that, do the arithmetic. All right, now we're talking about, we take those big numbers, now they're down to 19.5 or 30 million. 25% of that goes to Michigan cities. Some of it goes to counties, some of it goes to the state, but 1/4 of that comes to Michigan cities. The counties don't get any of the money, although the sheriffs do get some cut, but there's no money to counties per se. So now you take that 19 or 30 and you cut it down even further. So now we're down to a little more than 4.8, almost 4.9 or $7.5 million. Now let's assume your community's opted in and you have 1% of the total number of facilities. It's not provisioning centers, total numbers of facilities, growers, processors, secure transporters, compliance centers, et cetera, and you have at least 1% of those in your community. That's how much you're going to get. That's 1% of those big numbers. So is it worth between $50,000 and $75,000 for you to opt in? Assuming that's the scale of sales. Do the arithmetic. I can tell you for the city of Kalamazoo, $75,000 would cover the salary of one public safety officer. I mean, that's not counting, all the benefits. It would just barely cover one officer, and that's not talking about a car and all the other training that goes into that individual. So is it worth it? How many inspectors are you going to pay for? So that's a question you have to answer. Local options, and I think everybody knows, you can wait and see. A lot of communities are doing that. You can adopt an ordinance, or, as I said, you can or can't do. One of the things that I want you to be aware of, and again, if you're an attorney, you obviously already know this, but if you are in a home rule city, this decision may be taken away from you. If you've got in your charter an initiative clause, your local citizenry can say, we want an ordinance permitting this, and they circulate a petition, and it's on the ballot, and now you, as local officials, you've lost control. Or, and this is what happened in my community, rather than just an initiative ordinance, and again, your charter has to permit that, what your charter has to provide under state law is a charter amendment process. So not only do you take it, now it's not an ordinance, it's actually part of your charter that you've got to permit some type of medical marijuana facility. And that's what happened in Kalamazoo in 2010. I didn't draft it, this was an initiative by local citizens who said, we want at least what they call medical cannabis dispensaries in the community. And it was poorly written, but now I've got to deal with that in my community. Ordinances, if you do opt in, you're going to, as Jennifer indicated, zoning ordinance, or you're going to cluster, you're going to create a green zone, or you're going to disperse them. Are there deleterious effects associated with dispensaries and with processing and grow facilities? I've been told that there is an odor issue. Are you going to make sure that when you have those facilities up and running, that they have adequate air handling and control? What about the product that they don't use that is waste? Is it going to be properly disposed of? And let's face it, there are people who are going to be dumpster diving, hoping they can get whatever remnants are available. You laugh, and really think about it, people are going to do that. They're going to say, hey, they threw away all this stuff. There's got to be some usable. I mean, I've got to believe the industry is going to sap every bit of THC or cannabinoid out of the product that they can, but somebody's going to try to get a hold of that. Are they dealing with chemicals to do the refinery? Where's that going? How's that being disposed of? Do you have a wastewater treatment plant that you're going to see some of that effluent? What impact is that going to make on that operation? What kind of, in terms of, one of the things the legislature did, and I think one of the speakers who are going to follow me is talk about butane extraction. It blows up. Butane is a volatile gas. And the legislature said, oh, we were permitting home occupation, or, caregivers to be at home, do it in their home under the 2008 law. Homes blown up. Now you no longer, under state law, can do butane extraction in a residential area. But you can do it in a industrial or manufacturing area, but you no longer can do that at home because of the volatility. Well, what other gases are going to be stored. I'm told there's going to be stored CO2, and I think from my freshman college chemistry class, CO2 is fairly safe. But again, you need CO2 in order to make the plants grow well, I guess. And so you have to think about all those things. What's being stored? How's it being taken care of in terms of what you want to put in your ordinance to address that? And, you know, again, I'm neutral, but I have to say that early on, people who represented the industry said, you're thinking about opting in? Here's an ordinance. It was like 3 or 4 pages long. The city of Kalamazoo and our sister city, City of Portage, were both working on this, and our ordinances run to 30 pages. So, because there's all of this other stuff you have to think about. Again, some of the questions, should they be clustered? Should you be proactive? And that's the other issue. How are you going to discern? Again, you don't have to, once you open the door, you don't have to say it's unlimited. You can say, okay, we're only going to have 4 dispensaries. We're only going to have 2 processors or growers. When that happens, how do you pick the winners? Because there's a lot of money in the industry. And if they don't get something that they think that they are entitled to, or that they feel that you used a flawed or unfair system, even though they don't have a, quote, right, they're going to complain. You're going to see yourself, your municipality in court because of the process you used that was, quote, unfair. Or if you do have a process, you may have your local citizenry said, you were a little generous in granting the license, and that's going to impact me. I'm going to sue you because you granted the license. So you're caught between a rock and a hard place in terms of how you're going to approach this. And there are a variety of ways to do it. First come, first serve. You can use an evaluation system where you say, okay, we're going to look at these various components and we're going to score them, and there's going to be an evaluation. Okay, if you have one factor that's worth, say, 25 points, if you're satisfied you get all 25s, you're going to be, okay, this applicant gets the full 25, this one's not quite as good, we're going to give them 22, and this one's going to get 18. That person would have got 18, and maybe that cost them for getting a license. We're going to say, hey, wait a minute, well, how come I didn't get a few more points? You're going to be in that box. Special use permits under your zoning. Again, if you're familiar with that, if you do it as opposed to location by right, you're going to use the special use process. Special use is going to have to go before your planning commission and perhaps your city council or city commission. You, again, make thumb up, thumb down. If you make thumbs down, I can say, hey, you didn't use the right process, or you violated your due process, my due process as an applicant. So you want to get into that box. Again, consult with your attorney, consult with your municipal planners, consult with your local police and fire officials as to what you have to think about when you're approaching some of these issues. But again, you're not alone. Other communities are struggling with this. The Michigan Municipal League has got resources available. Firearms. I had an interesting conversation with the ATF official from Detroit a few months ago in terms of secure transporters. Marijuana and firearms don't work. There's some regulations there. So here's the way they get around it. It's an armored truck, and under state law, they don't have any identifications, unlike Colorado, that they emblazon the fact that they're transporting marijuana inside of their vehicle. You have to be kind of neutral. You're not broadcasting the fact that you're carrying cash and marijuana. You can't, those individuals, those employees in that truck can't carry firearms because they're going to violate ATF and federal law. So what they do is they have a trail vehicle, or maybe more than one trail vehicle. Those guys are armed to the teeth. Something to think about. Other public safety, health, and welfare issues, I've indicated the odor and getting rid of some of the byproducts. I'm not so much concerned about exposure to criminal and civil liability for city employees. If you open this up, I don't think the feds are going to come after local officials, although in Colorado, the governor and county officials were sued because a grow operation was located next to a very expensive vacation home, and they said the smell has now cut the value of our vacation vacation retreat, and Governor Hickenlooper and all the other people were sued. Now, the federal court excused the local officials, but they let that, and it was brought under the racketeering statute. They let that continue against the operator of the grow operation. So the homeowner who had, again, a very nice place in rural Colorado said, hey, the value of our home has been devalued because of the adjacency of this grow operation. And that is continuing in federal court. Again, I think that the news media said they've raised the signatures. This is reported how much. I mean, it's going to be a lot. In Michigan, if this goes through, Michigan's going to be one of the more liberal, most liberal, in terms of how much pot you can carry around with you. And the legal landscape has already had a seismic shift. Just last week, if some of you were probably aware, Attorney General Sessions indicated that the Obama-era guidance, I've rescinded all this, and it was like 5 or 6 memos. They just said no longer applicable. For those who are interested, it is and again, it's available online, Office of the Attorney General, and it's called Subject to Marijuana Enforcement. It's a 1-page memo from Jeff Sessions, and he indicates all of the, in a footnote, all of the Obama-era memoranda that were issued that are no longer applicable. However, Congress has already been involved in this, and what a lot of people are not aware is the Rohrabacher-Blumenauer Amendment. That is something that was adopted early, and it's been renewed periodically, usually as part of a rider to some other bill, in which they basically said, for those states that have medical marijuana, we're basically Justice Department don't go after these operations in those states. I mean, that's maybe too broad of a statement, but they basically said, hands off. That amendment is currently renewed periodically, and it was most recently renewed late last year, and it is scheduled to expire, however, I think on the 19th of this month. Stay tuned. If that amendment does not get renewed, then there is no protection for medical, and perhaps not even for those states that have tried attempted to legalize it. But there is already some pushback. There's some, and this is bipartisan. It is not one party or another. Representatives from those states are saying, what's going on here in terms of Jeff Sessions' remarks. But again, something else to watch for. Again, I'll be real quick. Engage your public, engage your community, engage your citizenry, because they're going to have perspectives on that you want to hear. And finally, I'll leave you with this slide. The industry is going to say that we're providing a much-needed product to patients who need it. And they sound very altruistic, and I'm sure that a lot of them are. But they wouldn't be doing that unless there was money to be made. And for those of you who are familiar with the series on the Showtime, Weeds, there's money to be made. That's why we do it. And there's the value, according to the Wall Street Journal last summer, in terms of the cash turnaround for a pound of marijuana. So with that, I thank you.
Our last speaker today is Bruce McCauley from the Drug Enforcement Administration. I'm going to ask you to please, if you have a question, please hold the card up so that our staff our runners can come and pick those up. Thank you.
Good morning. I've been asked to speak to the issues of how this is going to affect public safety and the unintended consequences as a result of allowing this into your communities. In preparing for this, I have reached out to our counterparts in Colorado to see how it's impacted things there and what type of issues have been proliferating there since they have legalized marijuana. Just to give some background, I was an agent and supervisor in Miami during explosive era when marijuana grows were developing in the South Florida region. The organizations that established themselves in that area proliferated and expanded into transnational criminal organizations that have kind of created a hold in the Colorado area. And in recent conversations with Michigan State Police, those same organizations have established themselves here in Michigan as a way of camouflaging themselves among the legal marijuana dispensaries and grows that are happening here. So how is this proliferation and expansion, exploitation of marijuana laws happening? The organizations are expanding and developing grow operations or using front operations, businesses that require licenses, etc., to launder their money. The waste that's reported from these businesses are actually being sold on the black market. Many times they're brokered to out-of-state clients where they can sell marijuana regionally here in the area. It might go for somewhere in the order of $1,000 per pound. On the East Coast, it'll go for around $4,000 a pound. These drug trafficking organizations are also using structured business licenses to conceal their involvement in these organizations. Criminals, felons, etc., use multiple structured licenses to conceal how much money is actually occurring in these businesses and filtering that money back out to buy properties where illegal grow operations are occurring. Typically, this is what we find in these operations and home grows. You might be surprised to find that due to the financial stress in many of these communities, it's happening in amongst rural communities. And this is what we typically find in these home grows. These homes are severely damaged and later on returned back into the community either through mortgage fraud or through rentals of properties where they pay the owners of the properties up front for a year in cash to dissuade them from inspecting their properties, and then they return a year later and find that their properties have been completely ruined. Many times we find industrial-sized AC units inside these homes during fires as a result of the illegal wiring. And as you can imagine, going into these homes as a fireman or something like that, unexpectedly finding wires strewn about, many times the structure is modified in a way that's unsafe for firemen to go through because holes are in the floor, piping or air conditioning unit hoses are routed through walls, stairways are modified, stairs, etc. in a smoke-filled home. Firemen are unexpectedly walking through those kind of corridors and environments and at risk. Many times when they abandon these homes, whether it be for one reason or another, the home is completely ruined from mold and it has to be remediated for that damage. Exterior indications that we many times see is damage to the home, exterior-wise as well, and indicators that there is a grow operation in the home. So you can see some of the damage that is created and the kind of threats that are made to first responders in going into these type of environments. Many times, these illegal operations hot tap into the electrical grid. They steal the electricity from the utility providers. They'll climb telephone poles or other apparatus to literally tap into these electrical lines while they're still hot and steal that electricity. They'll steal the electricity from their neighbors as well. As As you can see, many of these things these home grows have very crude installations and are obviously a threat to first responders. One of the things that was mentioned a little earlier was the butane hash oil extraction method. This is a means of purifying THC out of the stems, the waste plant material that some of these operations produce. They will scavenge the remaining waste of this and then use butane to purify it and put it into candies, gummy bears, chocolate, brownies, that kind of thing to produce a very high purity product for clients. Just to demonstrate what can happen, I don't know if I can, is there a way to move the mouse down to activate this video? I'm not sure. But in this video, is there a mouse for this to activate this video? Wanted to show, I guess it's active right now, at about 7 seconds. About 7 seconds, you'll see the helm in the center there literally blow the roof off approximately 3 feet vertically as a result of butane explosion. Those are the kind of things that our first responders might accidentally I do not know if anybody was in that home at that time, but obviously this is a Michigan State Police surveillance camera that recorded this event back in 2013. So these kind of things are going to be proliferating in your communities as a result of the camouflage nature that's going to be provided for these organizations in their communities. In addition, as previously mentioned, they use a great deal of chemicals to enhance the productivity of the plants that they grow. Many of these chemicals are then wasted into your water systems. And Flint has enough problems other than having this added to it. Many times these chemicals are leached into the plants themselves, and there's also some issues with the pesticides that they have been using to do this. In fact, in Colorado, one of the pesticides that they've identified inside marijuana, when burned, creates poison. All of this activity in legalizing marijuana creates an oversaturated market for the availability of marijuana, which proliferates the marijuana being available into the black market and expands out into the United States. We've received complaints from the neighboring states from Michigan on the proliferation of marijuana has increased in those areas. In addition, the number of cases of marijuana being shipped or delivered outside of Colorado has increased significantly as well. As previously mentioned, there are no means by which the local communities can limit the potency of the marijuana that's being produced in these businesses. And they've identified a rampant diversion from the medical marijuana or from even the businesses themselves in the recreational area going into the black market in Colorado. To give you an idea of the proliferation in Colorado, they have identified as of last July approximately 1,000 different types of dispensaries in the community, which far outnumbers the availability of Starbucks coffee businesses quite a bit, and also McDonald's. They also take advantage, as previously noted, that they take advantage of the extended plant counts in developing the businesses. So they'll structure the licenses together to produce very large grow operations or use multiple business licenses to set up several businesses that seem unrelated but are actually part of the same organization to exploit the number of plants that they can grow, and amongst that, camouflage and filtering marijuana out into the black market. As part of that purification process, they put the high purity THC into very attractive packaging for people to use, and it's also attractive to children. And you can see here that the number of issues that have occurred in children in the state of Colorado that has increased significantly as a result of this. I've previously mentioned about the use of pesticides in marijuana and how that filters into the plant material products as well, and that the EPA really hasn't engaged in trying to regulate any of that as well, because as we all know, marijuana is still federally illegal. The number of traffic fatalities associated with marijuana has increased significantly over the years. In the rate of approximately, somewhere close to, I checked the statistics, about 36% of the traffic fatalities were marijuana related alone. And as you can see, even though the Cole memo was recently superseded by the current Attorney General, and that limited or was to provide guidance as to what it should be to marijuana should businesses should not be targeted for. These are the type of statistics that have increased in Colorado as a result of the proliferation of marijuana dispensing there. You can see that since marijuana has increased, the traffic deaths have increased significantly. Since 2006, the amount of traffic accidents related to marijuana has now increased to somewhere around 25%. That's the most recent statistics have. Here's that demographic or the statistics on marijuana-related accidents. That information on the screen is from 2015. It's now increased in the statistics from 2016 to around 36% marijuana only. This is comparatively among all the states how it looks. Those in blue are the states that are non-legalized marijuana, and you can see how the marijuana use among 12 to 17-year-olds is significantly below the national average as compared to those that have legalized marijuana, medical marijuana, or recreational and medical marijuana. Comparatively, you may not be able to see it, but Michigan is over toward the right in there, just above the national average, and these statistics are from roughly 2015 at this point. Marijuana use between 18 and 25-year-olds within the last month have been a number in responding to the availability of marijuana there. This has significantly stressed the social support programs there and has caused those that have real challenges in finding housing and et cetera to be pushed aside by this huge influx of those who come there not seeking necessarily jobs and contributing to the community, but are looking to take advantage of the freely available marijuana. There is a report that was produced by the Mountain High Intensity Drug Trafficking Area, which is a multi-agency consortium, and they developed all those statistics on what has been occurring in Colorado. It's recently updated in October, and I encourage you to take a look at the publicly available report, the legalization of marijuana in Colorado, the impact, volume 5, and see for yourself the impact
Colleen will adopt rules permitting outdoor growers, thus preempting a local community from regulating odor control.
There is a provision that allows outdoor grows. However, the outdoor grows are required to meet the other requirements in the Act and the rules, meaning security measures. They will be inspected by the department. They have to be, fenced in, and the processing of the marijuana product needs to take place in a building that would be regulated under the department. So there is allowance for it, but it is on, there is limitations to that. And
The 72 Plant Caregiver Act, when will that end and when will the commercial go active?
Before you answer that question, that's where the intersection between local municipalities and what the state's permitting kind of is at a crossroads, because some municipalities said we're only going to permit indoor operations. Well, if the statute goes into effect that says you have to follow the rules, now you've been preempted from restricting it to inside grow operations for some of those very reasons, unless the rule makes an exception that the local municipalities can outlaw outdoor operations.
I think that's not been completely decided, depending on the facts of the case of what he's talking about. The department was very cognizant of the fact that the locals have their own jurisdiction, their own regulations, but we were charged with implementing the act from the state perspective. What was
The other question was, will the 72 Plant Caregiver Act, or when will it end, and when will it end when the commercial goes active?
Actually, no, that's a separate act. The caregivers and patients can continue to operate under the 2008 initiated law. So you can still be a caregiver, you can still be a patient, following the provisions of the odor initiative law.
Okay, thank you. Under the emergency rule, what monetary value is being placed on an inventory of 72 plants as a contribution toward the capitalization requirement?
It's part of 25% of your liquid assets, so that value would need to be figured out by the person that's submitting that as part of their capitalization assets.
Used for the marijuana industry.
The state has been researching that, holding meetings with people in the industry, in the baking industry. It's unknown at this point what's going to happen with the baking.
There's a question.
Let me follow up on that. House Bill 5144 addresses that. And so I think that may be one of the legislative fix that would permit either state or nationally chartered banks, credit unions, and likes, to permit them to provide their banking products to these facilities. Again, it's still unlawful under federal law, so even though you got the state that may permit that, just because particularly if you're a federally chartered institution, the state law is not going to necessarily protect you, I don't think.
Yes, and that's why I said it's unknown. It's still illegal.
Jeff, there's a couple questions for you. What kind of financial impact will these new bills and the increase in energy consumption have on household customers? So in other words, how much will residential bills increase, or will they increase due to the industry needing all this new expensive infrastructure?
Yeah, I don't see any impact on other customers for an industry growing. Typically, how construction incentives work on the utility side of the business and how we're regulated, there's an expectation that the customer is going to have an amount of load for a period of time, and that we're going to recover it in that customer's energy consumption. So again, I don't see any impact it's going to have on any other customers based off on how we do our infrastructure.
And then are there concerns about these businesses taking power away from a local community? So if there's only so much power to go around, will one of these facilities or more take energy away from a household user?
Yeah, I don't see it, we're not going to allow somebody to connect into our system and negatively impact other customers. That's why we're having this conversation. We want to make sure in any business, not just this industry, that's located in a facility, we have an understanding of their energy needs as they connect to the system, and the system can adequately serve them at the same time not impacting other customers. And so that's why we're having this conversation, so that we can go through this planning process and identify ways to make sure not only to serve this growing industry, but growing residential households as well as other businesses that may grow in a particular community. That's why having this early conversation is very important.
Jeff, one more. Would they be allowed to enter in curtailment, and how is this going to impact current energy grid?
Yeah, and because we have this industry's dynamic and energy consumption, even that of growers, can come in different sizes, really how they and what rate structure and what programs they enter into with any utility will really be governed by their energy needs and what they're willing to do or not do. So it really will be business specific, what type of rate programs they can participate in. But again, as these, depending on how these customers look, under our rates, we will treat them like any other customer with similar loads.
Thank you. Clyde, can a charter amendment work as an opt-in police power ordinance?
Probably. The charter amendment process does require vetting of those, and if it's citizen initiated, whether it's citizen initiated or your council initiates it, it is vetted by the Attorney General and the governor. And the governor has to approve the ballot language. Where the wrinkle comes in is if it's a citizen initiated charter amendment, the governor can say, I don't think this is a very good idea, I don't approve. It still goes on the ballot, and if it's approved by the voters, it goes into your charter. So, yes, in essence, as I said in my remarks, that decision can be taken away from you, and unfortunately, and this has been a pattern that's emerged in Michigan, both in terms of amending our state constitution and charters, they're starting to look not like charter language, but ordinance language that gets inserted in the Constitution or your charter. And unfortunately, that's the way it goes. And so, as I said, that decision may be taken away from you.
Clyde, one more. Once an SUP is issued for a certain piece of property, can that SUP be transferred to a different piece of property in the future for a marijuana facility?
SUPs, or special use permits, run with the land. They cannot be transferred to another parcel of land, but they can be done, however, is transferred to the new owner. So if somebody is granted a special use permit, and they say, I'm going to get out of this, I'm going to sell it, and I'm not going to sell the land to somebody else who wants to do something similar, it carries on to the next individual. So special use permits run with the land. They're not personal to the person, and they can't be transferred to another parcel.
Thank you. Jennifer?
But in that scenario, I believe, maybe Colin can clarify, the license would not transfer to another individual, even if the special land is
That's my understanding.
Thank you. Jennifer, as long as you have the mic there. The Michigan Municipal League publication states, location criteria can be established in the licensing ordinance without zoning amendment. How detailed would that be? And are there any examples of police power ordinances that have established two location criteria?
So that's going to depend on the community, what you put in there for those qualifiers. On our website, which was listed below the resource doc, we have any ordinances that have been passed that we have been sent to us or we have found, opt-in, opt-out, and so there is a listing of ordinances on our website that you can look at.
I think, Colleen, a lot of these are going to be for you. One of the questions was with the new sessions memo, recanting the Cole memo, what internally is being directed? Have the enforcement priorities changed? Has anything changed regarding medical marijuana marijuana enforcement regarding government funding and priorities and what's in a win? Do communities have to decide to opt in or opt out by a certain date? That's a different question, but really a lot of these relate to the session council.
I think that's a hot topic right now. A lot of people are asking that question. The department is charged with implementing the statute that the legislature passed. So the state of Michigan, as a department of the state of Michigan, we will continue to take licenses and issue licenses. It's really a question for the U.S. Attorney of Michigan or the U.S. Attorney General, I would say.
And then the last question on that card is, do communities have to decide to opt in and opt out by a certain date?
No, they can opt in, opt out, whenever they decide to. The only time there's a date involved, and that's with that rule on temporary operation. And the temporary operation, there's two parts to it. And in the first instance, a municipality could have passed an ordinance like a year ago, and they can then authorize an individual or an entity to operate if they decide under that ordinance. So it's, for lack of to explain it, an old ordinance. If they decided prior to December 15th to pass an ordinance under Section 205, the statute, then that person asking to operate temporary can take advantage of that provision. The person that wants to take advantage of the temporary operation would need to apply with the department by February 15th of this year. And it's not a license, it's just saying if you apply by that date, you have the authorization, then we're not going to hold it as an impediment against your licensure. So there is a date, and then the person would need to be licensed by the state by June 15th, and in that case, an ordinance would have to have been passed by June 15th.
Thank you. Special Agent McCauley, it seems the horse is out of the barn per se. Once this is legalized either by the legislature or a voter referendum, how can this best be handled by local law enforcement?
The enforcement apparatus at the federal level is prioritized to what threats most focused on the community. If there's any type of activity that is outside the boundaries that is set forth by the state, that is basically fair game, and those type of targets will be investigated and prosecuted as appropriate.
I'm not sure who to direct this one to, but there are actually a couple of them. What right does business have when an employee with a right to have medical marijuana come to work high? Anybody?
Clearly a legal question. It is, I would say, first off, if you talk to your local municipal attorney or your labor council, that give you better guidance. There is a federal case out of the Western District of Michigan involving, I want to say, Kmart or Walgreens, something like that. I think it was Kmart, in which the federal court said the employer was within their rights to end the employment, terminate the employment of an individual who came.
The same person has common interests. They can transfer the marijuana between the two separate and distinct areas.
Thank you. May a landlord rent a unit to a processor or compliance facility despite co-location restrictions? Assume the landlord is not an interested party or an investor, or a strip mall. Can that landlord rent a unit to a processor or a compliance facility?
Right. I think what this is referring to is there are restrictions on license types and if you can have an interest in the other types of licenses. For instance, a safety compliance facility and a secure transporter cannot have an interest in a grower, processor, or provisioning center, and it's vice versa. If someone wants to have perhaps it's a strip mall, and those two types of licenses want to operate there, I believe the director has said that, depending on the application and their facility plan, that might be okay as long as they're not owned by the same people, however. They can't be the same, they can't have the same interests in both licenses because of what the statute says.
If there are other questions, is there an opportunity for individuals or municipalities to contact somebody via phone or email, or have you prepared frequently asked questions, or how do they get their questions answered?
Yes, the department has, on their website, we have FAQs, we have the bulletins, the advisory bulletins. You can email the department, you can call the main line and talk to analysts. The phone number is 517-284-8599, and I also brought some cards that have our internet address on it, which also has our contact information and our email address. So these are available if anyone wants to pick one of these up.
Thank you. We'll get those and take them up front. Jeff, who do they contact at consumers? Do they just call the 1-800 number, or how do they, if they want to apply for one of these processes, who do they call at consumers?
Because there's many components to this, most of these projects can be handled very well within our typical 1-800 number and initiate a project that way. We do have a process internally that if it starts to exceed certain variables or certain things come up, it could get elevated to my team. If it is a growing facility in particular, I welcome you to reach out to myself, and we can certainly assist you with the process, and I have business cards for those that would like it after the meeting. If by chance you're not able to get the card from me today, contact your local economic development organization. They have us on speed dial, and they can get to us very quickly so we can assist you.
Thank you. And Jennifer, you said MML would be holding panel presentations with experts. Will those be open to the public, or are they limited to MML members?
No, our events are open to anyone. You would definitely have to register, and all of that can be found on our website.
So we'll make sure we have your website up. I think we had it on a slide, and we are videotaping this session, and we will have it available by link through the economic development organizations, the chambers, and the other organizations that are sponsors. Any final remarks from anyone on the panel?
I would just like to say the Michigan Township Association, MTA, also has a ton of resources on their website, has been doing educational events for their members. And so just if you are not a specific member of the league, but maybe are of MTA, they have a ton of resources as well.
I would just say that we welcome any questions and hope to provide answers. Information, feedback that we get is useful in our department to make sure that we are getting the regulations correct and can dispel any misinformation out there and provide clarification to anyone that wants to contact us. Thank you.
The other thing we've been talking to our members about is when an individual or a group is coming in to talk to you, be prepared to have questions to already ask them about utility usage, about size and scope, business plans, things like that, because that will help you filter those individuals who are walking in and have an entrepreneur spirit and want to try to get involved in the industry versus those who are know what they're talking about, have been doing their research, have possibly been involved in other states, things like that to help filter, because I know a lot of our communities have had a lot of individuals being contacted. And if you're called to say, I want to talk to you about a real estate development deal, and someone shows up in your office to talk about medical marijuana, that might be a red flag, that there was not the most upfront of what the meeting was about right from the beginning.
Well, thank you so so much. We hope this has been helpful to you. Please, let's give this panel a round of applause.